Oh, yeah, he would, but that was not for loans of money. What would that be for? For like buying if he would want to buy his daughter a camera or some new addition to their stereo, I would go ahead and first buy it on my Visa because I knew about stereos more than did, and then he would repay me later on. So when it came out to loans, what was the largest amount of money he ever loaned you? $4,000. I have no further questions, and the answer to the last question was $4,000. Is that right? Yes, it was. Any cross-examination? Yes, Your Honor. And did you repay that loan? No, I haven't repaid the loan yet. Do you still owe that loan? Yes, I do. To whom? Well, it would be to Clask, now that Ed is dead. Clask is whom? Clask is Ed's wife. Now, there were several photographs taken of you over the years. That's correct. Mr. Cooper took some of those. Dr. Cooper, excuse me. Most of the photographs that you saw pictured here, all of the photographs you saw pictured here were taken by Dr. Cooper. Yes, they were. Did any other members of the family take photographs of you? Yes, very often his daughters would hold the camera and take photographs of Ed and I, or just Ed, or just I. Yeah. Now, how many daughters did Dr. Cooper have? Daughters, 2 daughters. I have no further questions. Any further redirect based on that cross-examination? No, Your Honor. Have we completed the examination of this witness? Yes, Your Honor. Sir, thank you very much for having been with us this afternoon. Please step down carefully. Okay. Call your next witness. Okay. One moment, Your Honor. I have to see if my witness has arrived, Your Honor. Mr. Fred Mell. Mr. May, have we finished the slides? Yes, Your Honor. Why don't you bring the projector to the clerk so we can put them back in the proper order? We will need the forceps to put them in the proper order. Well, forceps weren't used to put in there, so it doesn't make sense. It is one thing holding them to the side and putting it in, and another thing to pull them out. Let's give her both and let her decide whether she needs them or not. Mr. May, is there any problem of knowing which packet those photos are coming from? No, that is what I was going to explain to her. Put a divider in between them. Please step over and do explain that to her. Maybe we will be able to just take the disc off. Sir, step up here behind the court reporter and stand and face the clerk. Raise your right hand, sir. You do solemnly swear the testimony you will give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please state your full name for the record. Fred Mell. Please spell your last name for the record. M-E-L-L. Thank you. You may take the stand. Frank Mell, your middle name is David. Welcome to this courtroom. Thank you. The microphone is live. I would like you to pull up close so your mouth is close to it. I want everyone in the courtroom to be able to hear you. It is a tradition of open public hearings to make sure both sides are having a fair hearing. Keep your voice up so everyone can hear you. You will be asked questions by the gentleman in front of you in the gray suit and by the gentleman who is standing towards us in the blue suit. All right, next, this is a 160. Okay, 160, we're starting off with direct examination by defense attorney. Defense attorney is Mr. May, M-A-Y. Plaintiff's attorney, Mr. Jensen, J-E-N-S-E-N. And I take that back. We're starting off with the court going into direct examination by defense. Okay? Cal State Fullerton, His major was physics. Mr. Mell, M-E-L-L. Dr. Cooper, Dr. Edward Cooper, C-O-O-P-E-R. Physics major. Sizzler, located on Yorba Linda Boulevard. Okay, how about motorcycle? You have a brief for that? Right? Here we go.
Cindy just wants.
Uh-huh. 160. 160, 4 boys for 5 minutes. Starts with the chord. If you hear the word objection, don't answer at all until I have made some kind of ruling. All right? Yes. Relax and have a nice time. Please bear with me. I am just getting over laryngitis. We certainly will. Try to get your voice to the back room. Please proceed. Thank you. Mr. Mell, are you employed right now? Yes. Do you go to school right now? Yes. And where do you go to school? Cal State Fullerton. And how long have you gone there? Since fall of 1980. And now, have you ever taken a physics course? Yes, I have. What is your major there? Physics. And you started there in 1980, is that correct? Yes, I did. Did you know a Dr. Cooperman? I am sorry. Did you know a Dr. Edward Cooper? Yes, I did. On or about when did you first meet him? Without checking my records, I would estimate spring of 1981. And where did you first meet him? In a physics course. And how many courses did you take from him? This is my second. The course that I was taking at the time when he passed on, it was the third course I have had from him. Okay. Now, did you know him? Did he also become a friend of yours? Yes, he did. When did he become a friend of yours beyond just a usual professor? Approximately halfway through the first physics course that I had with him. And could you tell me about that? He approached me when he noticed on the class that he saw that I was a physics major, and as a matter of what I presume was department policy, they tried to get to know the physics majors and see what they can do, you know, in the way of offering advice or course advice, picking courses and direction in that major, things such as this. Is that what he told you? No, it wasn't what he told me, just a conclusion I drew on my own. And that is your guess, right? Yes. What, in fact, did he say to you? What did he come up and say to you? I don't remember specifically. Did he ask you out to lunch? He suggested that we might talk about physics or my goals in physics over lunch. And where did he take you to lunch? Assumes facts not in evidence sustained. Okay. Did he take you to lunch? Yes. Where did he take you to lunch? Sizzler. And what Sizzler was that? The one on Yorba Linda Boulevard? Okay. And what day was this? Do you recall? No, I do not. Did there ever come a time when you had a regular luncheon day? What do you mean by regular? Well, a certain day of the week that you tried to make it to lunch to discuss physics with him? Yes. And what day of the week was that? Not one in particular, in general, just once a week. Once a week you would go to the Sizzler with him, or perhaps just across the street. Was there any particular day set aside for that? Usually Fridays, but it varied depending on my homework load or something like that. How long would you spend at lunch with him? It could vary between half hour to possibly, I suppose, an hour and a half. Do you own a motorcycle jacket? Yes, I do. Could you describe that jacket, please? I own 2 jackets. Could you describe those jackets? My first jacket, objection, irrelevant, Your Honor. Overruled. You may proceed to answer. Okay. I have 2 jackets. The first one that I had for the longest period of time. is a brown one, Mandarin style collar, a single zipper up the front, 2 pockets. How long have you owned that one? Since about 3 or 4 months before I bought a motorcycle. And what was the second one? My second one is a black one. It is offset zipper in front, Mandarin style collar, and a belt. Does it have any studs on the shoulder? No. Now, do you own a motorcycle? Yes, I do. How long have you owned a motorcycle? Again, without checking when I purchased it exactly, I would, if I remember, it was November of last year. Okay. Prior to that, did you own a motorcycle? No, I did not. Did you ever go motorcycle riding? Yes, I did. Okay, guys, let's start back in 20 minutes. Okay, but she was still upset about it, correct? Yes, okay. But it was during the day, so I don't know what time. Now, did she tell you that she hung up on O.J. Simpson? She hung up on June 2 or June 3 or thereabouts. No, I didn't know that. I didn't know that. Did she ever tell you what O.J. Simpson's reaction was when she hung up on him on the telephone conversations? No, I didn't know that. Okay. Nicole writes in this diary entry here, or whatever this document was intended to be, that O.J. told her as follows on June 3. You hung up on me last night. You're going to pay for this, bitch. You're holding money from the IRS. You're going to jail. You think that you can do any freaking thing you want. You've got it coming. I've already talked to my lawyers about this, bitch, and they'll get you for tax evasion, bitch. I'll see to it. You're not going to have a fucking dime left, okay? Now, do you know of any reason why Nicole would ever make up such a thing? Speculation? No, so if she wrote this down and said in her own handwriting that O.J. Simpson said these things to her, do you believe that they are true? Leading, yes. Excuse me? Yes. Does that shock you that O.J. Simpson would say those things to her? Argumentative and irrelevant. I'm shocked now because of you've never seen this before? No. You mean Mr. Simpson didn't show this to you during your talks at Rockingham? Argumentative. He didn't show this to you? No. He didn't say, look, Cora, look what I said to Nicole? No. I see. And Mr. Leonard didn't show you this? No, he didn't show me anything. Do you know who he is? Yes. Who is he? He is one of the kids from here. And is that a friend of Sydney? Yes. So when Nicole wrote here about him, that was Sydney's girlfriend in the same paragraph about the rest of this material, and that was true also, that she is a person who is a friend of Sydney, correct? Yes. Where does she live? Somewheres, I don't know. What is her name? I don't know. I don't know her name. So I know her as, what is her mother's name? I don't know. I don't know. I only know, I've seen her once or twice, so do you know who she is? Is she a friend of Sydney? Sydney, yes. And what is the name of her mother? Her mother? Yeah, I don't know. Have you ever talked to the Berman family about their conversations with Nicole on the evening of June 12? No. Have you ever talked to the family about this event on June? No. 3 or 4? No. Okay. Did your child sleep over at Nicole's house anytime in the month of June of 1994? Anytime? Yes, at Bundy. I'm sure, yes. Did she sleep over on the evening of June 3 with June 3? Okay. Of course, you never saw, withdrawn. Did you learn of any dispute or argument between Ron Fishman and Nicole about your going out with him? Do I know? Yeah. This is not the incident on June 11, no, but prior in time, no. When Ron and Nicole had an argument, and then Nicole called O.J. Simpson up and asked O.J. Simpson to speak to Ron, I didn't know that. You knew nothing about that? No. Okay. You were not at the Jenner's Christmas party in 1993? No. Correct? Did you tell O.J. Simpson that? When the prosecutors interviewed you in this case, they tried to slant your testimony or make you lie? Did you tell that to O.J. Simpson, that the prosecutors, they didn't make me lie, but they were trying to accuse me of saying, how could you be Nicole's friend if you don't know anything about the abuse? I said, but you know, I never saw it. You never saw it, right? Yeah, that doesn't mean it didn't happen, right? Leading and argumentative. I never saw, I thought it didn't happen, so no. Now that I have shown you these notes of Nicole's, you don't have any reason to believe that Nicole made all that up, do you? I don't think so. Leading, you don't think so, do you? No. Did you ask O.J. Simpson to have some footballs signed in 1994 and that he refused to do so for you? Do you recall that incident? Well, it was sitting there and then I thought he didn't sign it. You asked him to have the footballs signed for you? Well, no, I didn't. What happened was, I had Gigi said, if he has time, could you please sign these? These were not, these were from a friend of mine, and he was upset with you, and he didn't sign them initially, correct? Leading, so at the time, I didn't know he was upset with me. Okay, hold on. We need to change tapes real fast. We are almost finished. Now, before the tape change, I was asking you about an incident where you had requested O.J. Simpson to sign footballs, and you learned that he would not do so because he was upset with you. Could you relate that incident to us and tell us when it occurred? Leading, I just found out later on when Nicole told me that O.J. was upset with me, and I thought he was just busy because he was out of town and I had left that, I told Gigi to have him sign those. Why did Nicole tell you why O.J. was upset with you? At that time, I thought that because of my affair. And do you know why Mr. Simpson would be upset with you about your affair, particularly since he had a history of infidelity on his own part? Speculation, argumentative, because he thought that the reason why Nicole was going out, he thought that we were always going out, Nicole and I. He was, in other words, you got the feeling that O.J. Simpson was blaming you for Nicole's independence from him and her going out? Exactly. Leading all of the, all the going out, right. And you got the sense that O.J. Simpson was blaming you in part for the problems he was having in his relationship with Nicole, correct? Yes. Speculation leading, correct? Yes. And that's what Nicole told you, correct? Yes. Okay. Do you believe you did play a part in O.J. Simpson's problems with Nicole during this time? No, I don't think so. So you think O.J. Simpson was off base then? Vague, yes, I think so. Now, you were spending substantial amounts of time with him throughout May and June of 1994, correct? Irrelevant, what do you, vague, mean substantial? Okay, irrelevant and vague. You may answer, May or June, you said? Yes, not substantial amount. What do you mean substantial amount? Several times a week, 3 or 4 days a week. Yes, you were not home very often, correct? I was home most of the time, yes. Didn't O.J. Simpson blow up with you in a telephone call when you were pressing him to sign the footballs? Vague and leading, blow up? Okay. Jury charge. The decision herein passes only on the integrity of a criminal trial in the federal courts it does not determine the guilt or innocence of the petitioners, and we do not reach the other issues propounded in the lengthy briefs or which may be present in the trial record of 4,147 pages. The Solicitor General of the United States moved to remand the case to trial for further proceedings because of unfaithful testimony given before other tribunals by Joseph D. Maloney, a government witness in this case. The counter motion of petitioners asked for a new trial. The decision is based entirely upon the representations of the government in its written motion and on the statements of the Solicitor General during the argument on the motions. The petitioners were charged in a one-count indictment in the district court with conspiracy to violate the Smith Act. They were convicted, and the Court of Appeals for the Third Circuit, sitting in bank, affirmed by a divided court. This court granted the petition for writ of certiorari, and the case was scheduled for argument on October 10, 1958. On September 27, 1958, the Solicitor General of the United States filed a motion calling the attention of the court to the testimony given in other proceedings by Maloney, who was one of the 7 witnesses for the government in this case. On the argument of the motion, the Solicitor General, in response to questions by the court, stated with commendable candor that he believed the testimony given by Maloney on June 18, 1955, before the Senate committee was untrue. He likewise stated that he believed the testimony given by Maloney on July 2, 1958, in the Circuit Court of Florida was untrue. In addition to the Solicitor General's personal opinion, the text of the motion itself shows that the Department of Justice is certain that some of Maloney's post-trial testimony was contrary to the facts. Let's try that one again. Try that one again. The decision herein passes only on the integrity of a criminal trial in the federal courts. It does not determine the guilt or innocence of the petitioners, and we do not reach other issues propounded in the lengthy briefs or which may be present in the trial record of 4,147 pages. The Solicitor General of the United States moved to remand the case to the trial court for further proceedings because of unfaithful testimony given before other tribunals by Joseph D. Maloney, a government witness in this case. The counter motion of petitioners asked for a new trial. The decision is based entirely upon the representations of the government in its written motion and on the statements of the Solicitor General during the argument on the motions. The petitioners were charged in a one-count indictment in the district court with conspiracy to violate the Smith Act. They were convicted at the Court of Appeals for the Third Circuit, sitting in bank, affirmed by a divided court. This court granted the petition for writ of certiorari, and the case was scheduled for argument on October 10, 1958. On September 27, 1958, the Solicitor General of the United States filed a motion calling the attention of the court to the testimony given in other proceedings by Maloney, who was one of the 7 witnesses for the government in this case. On the argument of the motion, the Solicitor General, in response to questions by the court, stated with commendable candor that he believed the testimony given by Maloney was on June 18, 1955, before the Senate committee was untrue. He likewise stated that he believed the testimony given by Maloney on July 2, 1958, in the Circuit Court of Florida was untrue. In addition to the Solicitor General's personal opinion, the text of the motion itself shows that the Department of Justice is certain that some of Maloney's post-trial testimony was contrary to the facts. The decision herein passes only on the integrity of a criminal trial in the federal courts. It does not determine the guilt or innocence of the petitioners, and we do not reach other issues propounded in the lengthy briefs or which may be present in the trial record of 4,147 pages. Now, the Solicitor General of the United States moved to remand the case to the trial court for further proceedings because of untruthful testimony given before other tribunals by Joseph D. Maloney, a government witness in this case. The counter motion of petitioners asked for a new trial. The decision is based entirely upon the representations of the government in its written motion and on the statements of the Solicitor General during the argument on the motions. This is a suit under the Federal Tort Claims Act to recover money damages from the United States on account of the death of one Crowley caused by negligent operation of traveling cranes by various government employees in a federal arsenal located in Massachusetts. The act makes the United States liable for the negligence of its employees under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occurred. That provision makes the law of Massachusetts govern the liability of the United States for this tort. Now, the Massachusetts Death Act, in relevant part, provides that a person whose agents or servants by negligence cause the death of another not in his employment or service shall be liable in damages in the sum of not less than $2,000 or more than $20,000 to be assessed with reference to the degree of his culpability or of that of his agents or servants. Now, the assessment of damages with reference to the degree of culpability of the tortfeasor rather than with reference to the amount of pecuniary loss suffered by the next of kin makes those damages punitive in nature. That has been the holding of the Supreme Judicial Court of Massachusetts. The Tort Claims Act, however, provides that the United States shall be liable in the same manner and to the same extent as a private individual under like circumstances, but shall not be liable for interest prior to judgment or for punitive damages. If, however, the law of the state provides for damages only punitive in nature, the United States shall be liable for actual or compensatory damages measured by the pecuniary injuries resulting from such death to the persons respectively for whose benefit the action was brought. This is a suit under the Federal Tort Claims Act to recover money damages from the United States on account of the death of one Crowley caused by negligent operation of traveling cranes by various government employees in a federal arsenal located in Massachusetts. Now, the act makes the United States liable for the negligence of its employees under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of